Hello everyone, I hope this video finds you well. I'm here for a bit of a small discussion. Actually, we have decided to start a judgment series wherein we'll be covering all the important judgments regarding the topics that we have already covered on our channel. So to begin with, the judgment that I have chosen to discuss today is LGW Industries Limited versus Union of India. Now, this is not a sensational judgment, but it carries a very important point with it. What are the courts exactly dealing with when it comes to the allegations that the revenue level against the assessees that their transactions are not genuine, and based on that argument they deny the availment of ITC. So to set things in perspective, I shall first lay in front of you broadly the facts of the case. The facts of the case are such that the petitioners were denied the availment of ITC and were asked to pay interest along with penalty on four major grounds, which are that the suppliers of the petitioner were fake and non-existent. This is number one. The second allegation is that the registration of such suppliers were cancelled with retrospective effect by the department. Third is that the claim of ITC by petitioners were not supported by valid documents. And the fourth is petitioner did not verify, or at the least did not do their best in verifying the existence of such suppliers. Now let us start by diving deep into each and every allegation so to understand the position of the department better. The first allegation is suppliers are fake and non-existent. What this essentially means is that the suppliers are merely raising invoices and not actually supplying goods. Or it can also mean that when the department tried to find out the location of the suppliers, they were not available. Well, is this a ground to deny availment of ITC? Certainly not. I mean, section 16 does not mention it, that your supplier must exist, and if he doesn't exist, then your ITC won't be available to you, right? So the second allegation is registration of the suppliers were cancelled with retrospective effect. Look, department has got two options when it comes to cancellation of registration. Either it can cancel the registration prospectively, or if it deems fit, it can cancel the registration with a retrospective effect. Now what this means? This essentially means, for example, today is 1st of January, let us assume, and the department cancels the registration today with retrospective effect starting from 30th of November. So even if your registration is being cancelled on today, that is 1st of January, it will be deemed to be cancelled from 30th of November. Department generally does this when it believes that the registration has been obtained by unlawful means and that the registration is bogus. Now moving forward to the third allegation, that is the claim of ITC is not supported by valid documents. Now friends, as we know, section 16 mentions of the various documents that are required in order to be able to avail ITC. One of such is a valid tax invoice. The fourth allegation is petitioners did not verify the identity and genuineness of a supplier. Now, is it required under the law that the petitioners or the assessee must verify the genuineness of their suppliers? So based on these four broad grounds, the petitioners were denied the availment of ITC and were asked to reverse the ITC along with interest and penalty. Now, aggrieved by this order, the petitioners approached the Honorable High Court of Calcutta and argued, number one, that the suppliers existed at the time of transaction and their registration was active. Now, if the department retrospectively cancelled those registrations, it has got nothing to do with the assessees, and the assessees could not be made liable in such a scenario. The second argument that they advanced was that all payments were made through banking channels and not via cash within 180 days. The third is details of invoices are being reflected in their form GSTR 2A. Now, as you are aware, friends, that this is also one of the requirements that section 16 entails. The fourth is that the revenue is unreasonable when it says that the ITC is denied merely because the suppliers are not existent. They instead have to prove that the transaction on which ITC is being denied is a result of collusion between the suppliers and the recipient. And if they fail to prove that, then ITC cannot be denied. So, on the basis of the facts recorded and arguments advanced by the recipient petitioner, the court came to the following conclusion. It said that prima facie there is no failure on the part of the petitioner assessee to verify the genuineness of its suppliers, because the petitioner went to the GST portal and checked the status of registration of their suppliers. At that time, the registration was active. Now, that's a different question that the revenue cancelled it later on with retrospective effect. They are not concerned with that. Further, it remanded the matter back to the revenue for reconsideration and said that, not really said, directed the revenue that if all the documents of the petitioner recipient are found to be in order, then there stands no reason why that ITC should be denied to them. Therefore, what we can draw as a conclusion, or as a very important conclusion rather, that the courts are merely concerned with whether the transaction is genuine or not, and they are only going that far and not further. So my suggestion would be that you as a businessman should have in your possession all the documents which can tell that your transactions are genuine, and if you are able to distinguish that, then there stands no reason why that ITC should be denied to you. It should not be. So friends, that was the judgment. In future we intend to bring more such judgments, and if you are interested in seeing our section 16 video, please refer to the link in description. Thank you. Keep supporting us.